네, 지금부터 2023 국제특허법원 컨퍼런스 1세션을 시작하겠습니다. 1세션은 각국의 IP 소송 관할과 IP 전문법원의 운영 현황에 대해서 살펴보겠습니다. 1세션의 진행은 구자헌 특허법원 고법판사께서 맡아주시겠습니다. 큰 박수 부탁드리겠습니다.
네, 안녕하십니까. 1세션 진행을 맡은 구자헌 판사입니다. IP 소송은 기술과 법에 관한 전문 지식과 상당한 경험이 필요하고 판결이 산업에 미치는 영향을 고려할 때 전문화가 더욱 요구됩니다. 1세션에서는 각국에서 채택하고 있는 전문화 제도를 공유하고 바람직한 제도가 무엇인지 논의하는 시간을 마련하였습니다. 먼저 세션에 참여하시는 패널분들을 패밀리네임의 알파벳 순서에 따라 소개해드리겠습니다. 큰 박수로 환영해 주시기 바랍니다. 먼저 미국 애리조나 연방지방법원의 데이비드 캠벨 판사님이십니다. 영국 IPC의 리차드 헤이콘 판사님이십니다. 일본 지적재산 고등재판소의 히로아키 이마이 판사님이십니다. 한국 특허법원의 이지영 판사님이십니다. 특허법원의 한지윤 판사님이십니다. 네. 1세션은 각국의 지식재산 전문법원 제도, 관할, 지식재산 전문 법관 제도, 기술조사관 로컬럭 제도 등의 활용 현황, 전문심리위원 전문가 정인, 제3자 의견 진술 제도 등을 통한 전문화를 논의할 예정입니다. 5개 세부 주제에 대해 미리 각국의 패널분들에게 질문을 전달하였고 패널분들께서는 아주 상세한 답변을 보내주셨습니다. 질문과 답변은 자료집에 모두 포함되어 있고 오늘 질문과 토론은 자료집에 기재된 순서로 진행됩니다. 다만 원활한 행사 진행과 토론의 효율을 높이기 위해 세세한 질문은 모두 통합하여 각 세부 주제별로 하나의 질문만 드리도록 하겠습니다. 패널분들께서는 패밀리네임의 알파벳 순서로 답변해 주시기 바랍니다. 캠벨 판사님, 헤이콘 판사님, 이마이 판사님, 그리고 한국 판사님들 순이 되겠습니다. 먼저 첫 번째 토픽에 대해서 보면은 첫 번째 토픽은 IP 소송 전문 법원 제도를 다뤄보겠습니다. 패널 분들께서는 기국에 IP 소송 전문 법원이 있는지 있다면 구성 및 업무 영역을 소개해 주시고 전문 법원 내 재판부나 법관별로 담당 분야를 달리 정하고 있는지도 함께 알려주시면 감사하겠습니다. 각 4분 내로 발표해 주시면 되겠습니다. 먼저 미국의 데이비드 캠벨 판사님 부탁드리겠습니다.
Good morning. It's a pleasure to be with all of you. Can you hear okay? Okay. I am delighted to be with you. I am a federal judge from Arizona in the United States. I also chair the International Judicial Relations Committee for the federal courts in the United States. And in that capacity, I extend to you the greetings of federal judges from the United States. We are privileged to be able to participate in this program and to be invited to learn from so many experts here. The answer to the question of whether we have specialized IP courts in the United States is partially. Let me give you a bit of background. Traditionally, we are general jurisdiction courts in both the federal courts and the state courts of the United States. Federal district judges, which is the first instance trial court of the national court of the federal court, are appointed for life by the President, confirmed by the United States Senate, and they hear all categories of federal cases in the United States. So they hear criminal cases, civil cases, administrative cases, IP cases. There is no specialization. The decisions of these judges often is made with a jury trial where a jury decides the most central issues, and that's a constitutional right in our country. So of necessity, necessity, the Constitution dictates that we not have specialized courts in the first instance. The decisions of these federal district courts get appealed to regional circuit courts of appeals. There are 12 of them in the United States. I'm in the 9th Circuit, which is the western part of the United States. Judge Chang is in the 7th Circuit, which is in the middle part of the United States. There are, however, against this backdrop of generalized courts, 2 areas in which we have IP specialization in our courts. The first is that in 1982, the United States Congress established a specialized appellate court for patent cases. That is known as the United States Court of Appeals for the Federal Circuit. It is the only specialized federal court of appeals and the only federal court of appeals that is not based on geography, but is based on subject matter. The Federal Circuit sits in Washington, D.C. It consists of 12 judges. It was created to provide expertise in patent matters and to establish national uniformity in the decision of patent cases. And so since 1982, that Federal Circuit has established a large body of case law on patent issues in the United States on matters such as how to interpret claims, how to determine infringement, how invalidity of a patent can be established, and what damages can be awarded in a patent case. The judges on the Federal Circuit Court of Appeals do not specialize in particular subject matter areas. They sit in panels of 3, and the cases are assigned to them randomly. We don't have specialized divisions within the Federal Circuit. A party dissatisfied with a 3-panel decision can appeal to the entire Federal Circuit, but that sort of appeal is rarely granted. And the Supreme Court of the United States can review the decisions of the Federal Circuit, although it doesn't do so very often because it recognizes that those are the specialist judges. That's my wife's phone telling me my time is up. There's a second category I will just mention of, it was very good, Stacy. There's a second category of specialized judges who are in administrative agencies of the United States, the Patent and Trademark Office, the International Trade Commission. I'll say more about those in a minute.
네, 감사합니다. 데이비드 캠벨 판사님께서 많은 준비를 해주셨는데 질문 시간이 너무 짧았던 것 같습니다. 다음으로 영국의 리차드 헤이컨 판사님께 부탁드리겠습니다.
Thank you very much. It's a great pleasure to be here. My second time at a conference, an IP conference in Korea. And my experience on both occasions is how well they've been organized and how useful I think they've been to all participants. And I expect this one to be exactly the same. I'm going to be speaking about the system in England and Wales. In the United Kingdom, there are 4 separate jurisdictions: England and Wales, Scotland, and Scotland and Northern Ireland. There's only one United Kingdom court, and that's the Supreme Court. So I'll be just discussing the system in England and Wales, or sometimes for short, England. Civil procedure in England is divided into 2 types of court: the High Court for more complex cases and the County Court. Almost all IP litigation happens in the High Court, so I'll be talking just about that. Are there specialized courts? Yes, we have specialized courts and specialized judges. We divide types of IP into 2 broad groups. There's one group which contains patents and registered designs, and it's in respect of those that we have specialized courts. They also deal with semiconductor topography rights and plant variety rights, but those last 2 hardly ever litigate, so I will say nothing about them. The more general IP cases: trademarks, copyright, unregistered design, database rights, performance rights, and trade secrets. They're treated separately. There are no specialized courts for those except one, and that's the one I sit in, and I'll say something about that in just a moment. So for patents and registered designs, there are three courts. There's the Patents Court. These are all in the High Court. These are Patents Court, which deals with more complex cases, usually substantial litigation between multinationals. There's the Intellectual Property Enterprise Court, IPEC, which deals with less complex cases and is designed to conduct litigation in IP more quickly and at less cost. Also, there are the general courts. The specialized courts have specialized judges. They all have been either barristers or solicitors who specialized in IP for their careers, like me, and they are selected from those people. There is also another court which deals with very simple cases, usually for litigants without professional representation, which is called the Small Claims Court. That doesn't do patents or registered designs, but it does all the other types of IP. There are two permanent judges in the Patents Court, two specialist judges. There's one permanent judge in IPEC, that's myself, but both courts have other judges who sit from time to time. For the general IP cases, that's to say trademark, copyright, and so on, those can be heard by judges who aren't specialists. It's a matter of chance whether a case goes to a specialist judge or a non-specialist judge. Specialist judges like myself sit not just in patents and registered designs. We do all kinds of IP. So if you've got a general IP case, you may get a specialist judge and you may not. Litigants are not allowed to present their cases in a language other than English, but in Wales, you're allowed to present your case in Welsh. Apart from that, everything has to happen in English. And that's broadly the system that we use in England to conduct IP cases. Thank you.
감사합니다. 다음으로 일본의 히로아키 이마이 판사님 부탁드리겠습니다.
Thank you. Okay. Ladies and gentlemen, thank you very much for me to. This is my great honor to participate in this conference. IP specialized code. Do you have specialized code in Japan? Asking. My answer is yes. IP High Court is the specialized court directed on to the IP-related cases. And generally cases, including patent infringement cases, are first tried in a district court. The judgment of a district court can be appealed to a high court and then to the Supreme Court. At first instance, two district courts have exclusive jurisdiction over patent cases. In Japan, claims of patent infringement occurring in Eastern Japan are subject to the exclusive jurisdiction of the Tokyo District Court. And those occurring in Western Japan are subject to the exclusive jurisdiction of the Osaka District Court. The Tokyo District Court has 4 special divisions, and the Osaka District Court has 2 special divisions for intellectual property matters. Appeals from district courts in patent infringement cases come under the exclusive jurisdiction of the Intellectual Property High Court, IP High Court. It was established in April 2005 as a special high court dealing with IP matters only. The IP High Court has 4 general divisions and 1 special division where a panel of 5 judges hears and decide cases. Final appeals from the IP High Court are filed with the Supreme Court. Supreme Court cases are usually heard by one of the 3 petty benches composed of 5 justices. And foreign language, allowing the foreign language question. The answer is no. Courts Act Article 74 stated that Japanese is the language used in court, so we don't have any foreign language divisions. Thank you. That's all my experience.
한국의 한지윤 판사님 부탁드립니다.
예, 저도 이런 자리에서 귀빈 여러분들 오시고 또 저희 나라 제도에 대해서 잠깐 간략하게 설명드릴 수 있어서 기쁘게 생각합니다. 대한민국에서 지식재산권 관련 사건은 일단 청구의 내용과 권리의 종류에 따라서 특허심판원, 특허법원 또는 민사소송법에 따라 정해진 몇 개 지정된 법원에서 처리를 하고 있습니다. 다만 특허법원은 지식재산권 관련 사건을 전문적으로 처리하는 법원으로서 1998년 설립됐습니다. 특허법원은 이례적으로 전국을 관할하고 있고요. 특허법원의 심결에 대한 취소 소송의 제1심과 특허권 등에 관한 민사 본안 사건의 항소심을 전담하고 있습니다. 저희 특허법원은 총 5개의 재판부로 구성이 되어 있습니다. 재판부 또는 법관별로 담당 업무 분야가 특정이 되어 있는 것은 아니고요. 3인의 법관으로 이루어진 하나의 재판부에서 심결 취소 소송과 민사 항소 사건을 함께 처리하고 있습니다. 상표, 특허 등의 권리의 유형별 또는 어떤 기술의 영역별로 다른 사건, 이렇게 일정한 사건만을 전담하는 것은 아닙니다. 그리고 질문 중에 외국어 사용에 관한 질문이 있었는데요. 원칙적으로 대한민국에서 모든 소송 절차는 한국어로 진행이 됩니다. 다만 당사자를 외국인으로 하는 지식분쟁 사건이 점차 늘어나고 있는 추세이기 때문에 지금 특허법원과 서울중앙지방법원에 국제사건을 전담하는 국제재판부가 설치되었습니다. 그 당사자 일방이 외국인이거나 주요 증거조사가 외국어로 진행이 될 필요가 있을 때 양 당사자들이 동의를 하면 법원의 허가를 얻어서 외국어로 법정에서 변론을 할 수가 있습니다. 저희가 이러한 사건을 국제사건이라고 부르는데요. 앞서 말씀드렸던 특허법원에서는 5개 재판부 중에 일부가 국제재판부로 지정돼서 국제사건을 처리하고 있습니다. 허용되는 외국어는 원칙적으로 영어인데 당사자의 신청에 따라서 영어 외에 다른 언어가 사용이 될 수가 있습니다. 다만 법원은 외국어 변론으로 인해서 재판이 현저히 지연될 것으로 예상되는 경우에는 허가를 하지 않을 수 있고 이미 이루어진 허가를 취소를 할 수도 있습니다. 이상입니다.
이제 논의를 이어서 이번에는 토픽 2로 관할에 대해 살펴보겠습니다. 패널 분들께서는 특허권, 상표권, 디자인권의 등록 무효 및 취소, 등록 거절, 침해 금지 명령, 가처분 사건의 관할 법원을 소개하여 주시고 신급별로도 상세히 설명하여 주시기 바랍니다. 마찬가지로 4분 내에 발표 부탁드리겠습니다. 먼저 데이비드 캠벨 판사님 부탁드립니다.
I think the easiest way for me to explain jurisdiction would be to go by subject matter for different categories of cases in the United States. Issues of patent registration or patent revocation or cancellation commonly are heard before, let me start that over. Issues of patent registration or patent cancellation or revocation are commonly heard before an administrative agency, the United States Patent and Trademark Office. that has about 200 administrative law judges within the agency to hear these matters. Decisions by that agency get appealed to the Federal Circuit that I mentioned a moment ago that specializes in patent matters. Cases that involve patent infringement typically are heard in federal district court before non-specialized judges and juries. And those decisions also get appealed to the Federal Circuit. So all patent cases from all parts of the United States go to the Federal Circuit. There is also another administrative agency that can hear infringement issues. That is the International Trade Commission, that addresses allegations that a product being imported into the United States infringes a United States patent. And the ITC, as it is called, also has administrative judges who hear those patent matters. Their decisions get appealed to the Federal Circuit. With respect to copyright cases, a claim for copyright infringement is brought in the general jurisdiction federal district courts before non-specialized judges and juries. And the appeal of decisions in copyright cases goes to the regional circuit courts of appeal, not to the Federal Circuit. So the appeal goes to non-specialized judges as well. With respect to trademark matters, those are generally governed by a federal statute, the Lanham Act as it is called. There is a trademark trial and appeals board within the United States Patent and Trademark Office that will hear disputes about whether or not a trademark should be registered, and their decisions are appealed to the Federal Circuit. But claims of trademark infringement or related unfair competition are heard in the general jurisdiction district courts, and those decisions are appealed to the regional courts of appeals. Finally, with respect to trade secrets, trade secret law is often a matter of state law, can be heard by state court judges, but in the federal system, those trademark claims are heard by the general jurisdiction district courts, and appeals are made to the regional circuit courts of appeals. So as you can see, IP cases go in a variety of different directions in the United States and often are heard by non-specialized judges. The last question that was asked of us is whether the United States is contemplating further specialization. I think the general answer is no, because of our constitutional right to a jury trial in the first instance, although we did do a 10-year test of more specialized patent courts through what we call the Patent Pilot Project that I can describe later. Thank you.
네, 감사합니다. 다음으로 영국의 리차드 헤이콘 판사님 부탁드립니다.
Thank you. Jurisdiction in England and Wales depends on the division in subject matter I mentioned a moment ago. On the one hand, patents and registered designs, which are heard by the specialist courts, and on the other, the more general IP, copyright, trademark, trade secrets, unregistered designs. Those are heard by the more general courts. So beginning with patents and registered designs, there are three tribunals which may hear a case. One is the Patents Court for large litigation between multinationals. The second is IPEC, which hears smaller cases and has a much more streamlined approach. The third tribunal is the UK Intellectual Property Office, which has control over the prosecution and grant of patents and registered designs. You can bring an action for infringement there, but it has no power to order an injunction, so it very rarely happens. But it's not unusual for an application in the UK Intellectual Property Office to be made for revocation of a patent or registered design. Where there are the same proceedings in the UK Intellectual Property Office and in a court, the UK Property Office will always decline jurisdiction, and it goes to the court to avoid two sets of proceedings being conducted at the same time. So what about the more general IP cases? Well, those are heard by, as I mentioned a moment ago, non-specialist judges or sometimes specialist judges either in the General High Court or in IPEC, or sometimes in the Intellectual Property Office. And there's a fourth place you can bring proceedings for those, and that's in the Small Claims Division, which is for cases where damages are limited to £10,000. Usually they are not professionally represented, photographers and so on. So how do you pick which tribunal to bring your case? Well, the claimant, the plaintiff, gets to choose. They can pick whichever they prefer. A large multinational will always pick the Patents Court or the General High Court if it's not a patents case. And smaller litigants will pick a smaller court. But either party can always apply to transfer, and those applications happen quite often to move up or down or whichever direction. So far as appeals are concerned, appeals from the Patents Court, the General High Court, and from IPEC all go to the Court of Appeal. Appeals from the small claims go to IPEC. Appeals from the UK Intellectual Property Office go to either the Patents Court if it's a patent or registered design case, or they go to the General High Court. You can appeal from the Court of Appeal to the Supreme Court, but only with permission of the Supreme Court. And the Supreme Court will only give permission if it's an appeal involving a point of law which is of general public interest. And they hear, I would guess, no more than 2 or 3 IP cases each year. So it's quite unusual to get an appeal to go that far. Thank you.
히로아키 이마이 판사님 부탁드리겠습니다.
Okay. Our jurisdiction of IP litigation, I can say in one word, we have the bifurcation system, like German system and Korean system. So, if you cannot understand my explanation, you can understand after me that her explanation. You can understand the bifurcation system. So, and litigation for the IP infringement starts from the district court. I have already explained, and I will explain this time the litigation concerning invalidity. Patent law grants the Japan Patent Office the authority to determine patent invalidity. To invalidate a patent, a person must either file a trial with the JPO for invalidation or file an opposition with the JPO for cancellation. In a patent infringement case, a court can also deny enforcement of the patent at issue if there are grounds for invalidation. However, a court judgment on patent invalidity under Article 104/3 is only binding on a patent to the particular cases, and the JPO still has the authority to declare the general invalidity of patents through a trial for invalidation. Any suit against this, appeal or trial decisions made by JPO is under the executive exclusive jurisdiction as a revocation action of IP High Court. Although the existence of 2 different procedural tracks for patent invalidity action raises the issue of how to resolve contradictions between the decisions of the courts and JPO. The IP High Court is expected to apply consistent interpretation as an appellate court for both infringement litigation and invalidity trials. Among IP-related civil cases, so-called non-technology-related actions relating to design rights, trademark rights, the rights of authors, publication rights, and so on. Infringement of business interests caused by unfair competition are also that. They are under the jurisdiction of 50 district courts located throughout Japan, while the Tokyo District Court or the Osaka District Court concurrently has non-exclusive jurisdiction. Any appeal against decisions of those courts will be under the jurisdiction of one of the 8 high courts located throughout Japan that correspond to the district court in charge of the first instance. The Intellectual Property High Court will be in charge of any case that is under the jurisdiction of the Tokyo High Court. Okay, thank you.
네, 감사합니다. 다음으로 한국의 한지윤 판사님 부탁드립니다.
지식재산권 관련 사건의 청구의 내용과 권리 종류에 따라서 관할을 간략히 설명드리도록 하겠습니다. 먼저 특허권이나 상표권, 디자인권 등의 등록된 권리의 효력과 범위에 관하여 다투는 경우에는 먼저 당사자가 특허 심판원의 무효 심판 또는 그 거절 결정에 대한 불복 심판, 권리 범위 확인 심판을 청구를 해야 합니다. 그 특허 심판원은 특허청장에 소속된 행정심판기관에 해당하고요. 특허 심판원의 심결에 불복하려면 법원에 해당 심결에 대한 취소 소송을 제기해야 되는데 심결 취소 소송은 저희 특허법원에 관할이 있습니다. 다음으로 그 침해 소송에 대해서 말씀을 드리겠는데요. 이제 보통 손해배상 청구와 그 금지 청구 등을 생각을 해보시면 되겠는데 그 앞서 말씀드렸던 특허권, 디자인권 등의 그런 등록된 권리의 경우에는 그 관할이 집중됩니다. 이러한 소를 제기하는 경우에 제1심은 서울중앙지방법원, 수원, 대전, 대구, 광주, 부산지방법원 중에 하나에 전속 관할이 있습니다. 다만 당사자의 선택에 따라서 서울중앙지방법원에도 중복 관할이 인정이 됩니다. 그리고 그 항소심은 아까 말씀드렸다시피 특허법원에 전속 관할이 있습니다. 다만 그 특허권 등을 제외한 지식재산권의 경우 이제 대표적으로 저작권을 생각을 해볼 수 있는데요. 이러한 경우에는 그 관할 집중이 이루어지지 않아서 일반 민사사건에서와 같이 민사소송법에 의해서 관할이 정해집니다. 다만 이에 더해서 해당 법원 소재지를 관할하는 고등법원이 있는 곳의 지방법원, 그 아까 말씀드렸던 그 6개 지방법원이 해당이 됩니다. 그러한 법원의 중복 관할이 인정이 되고 그 항소심은 제1심 법원 소재지를 관할하는 고등법원에서 처리를 하게 됩니다. 마지막으로 가처분 사건의 경우에는 권리 종류와 무관하게 관할이 집중이 되지 않습니다. 그래서 민사 가처분 사건은 그 일반 민사소송법에 따라서 관할이 결정이 되고요. 지금 현재 국내에서 형사사건과 부정경쟁방지법 위반 사건의 경우에는 지금 현재 관할이 집중되지는 않지만 이들 사건에 대한 관할 집중에 관한 논의가 이루어지는 것으로 알고 있습니다. 이상입니다.
네, 감사합니다. 다음으로 토픽 3으로 전문 법관 제도에 대해서 알아보겠습니다. 법원의 전문화 이외에도 사건을 맡은 법관이 기술에 대한 이해가 있어야 재판의 효율성이 높아지고 또 재판에 대한 신뢰도 높아질 것으로 생각이 됩니다. 기하의 국가에 IP 전문 법관 제도가 있다면 선발 기준, 자격 요건, 근무 형태, 현황 등을 포함하여 자세히 소개하여 주시기 바랍니다. 또 전문 법관 제도를 두지 않는 국가라면 IP 소송에서 요구되는 법관의 전문성을 어떻게 확보하는지, 별도의 법관 교육 프로그램을 운영하는지 알려주시기 바라고요. 또 기하가 생각하는 전문 법관 제도의 장점과 단점도 밝혀주시기 바랍니다. 그리고 캠벨 판사님께는 패턴 파일럿 프로그램에 대한 소개도 부탁드립니다. 먼저 미국의 데이비드 캠벨 판사님 부탁드리겠습니다.
Thank you. The two categories that I mentioned a moment ago, the federal circuits and the administrative agencies that have specialized judges within them. Let me just say a word about the qualifications of those judges. Federal circuit judges, like other federal judges in the United States, are appointed by the President, confirmed by the Senate, and there is no requirement for judges going on the federal circuit to have a particular background in technology or science or patent-related issues. However, as you can imagine, often that's what a president looks to in appointing judges to that court, so many of them have that sort of background qualification, and they acquire expertise when they are on the court. The administrative judges within the Patent Trial and Appeal Board and the Trademark Trial and Appeal Board in those agencies that I mentioned are appointed by the Secretary of Commerce. They must have a college degree in engineering or a scientific discipline and at least 10 years of IP experience in order to be appointed to those positions. With respect to the rest of us who hear cases who are generalists, there are resources and training programs that can help us become more proficient in IP law. There is an arm of the federal courts called the Federal Judicial Center that is the training organization for federal judges. And the Federal Judicial Center holds a program every year on patent law and litigation that is available for judges to use. The Federal Judicial Center publishes a very comprehensive case management guide for patent cases that generalist judges can use when they are handling patent cases. And there are some courts in the United States that hear more patent cases than others just by virtue of where they are located. And they've promulgated local rules and practices that are often used by other judges around the country in patent matters. Let me say a word about this patent pilot program that I was specifically asked about. This was a pilot program established by Congress that ran from 2011 to 2021. The idea was to give some general jurisdiction district judges more experience in patent cases and see what effect that had on their efficiency, on the consistency of their decisions, the reversal rate when decisions went to the federal circuit. There are 94 federal districts in the United States, and 13 of them were put in this patent pilot program. And in those districts, judges could volunteer to be a patent pilot judge, in which case they would keep all of the patent cases that were assigned to them, and the non-patent pilot judges in their district could send them patent cases, so they got a heavier dose of patent cases. That practice was followed for 10 years, and the Federal Judicial Center that I mentioned a minute ago did a very thorough study of what effect it had on the cases that were handled by these pilot program judges who had more patent cases versus other generalists who did not. The finding of the study was somewhat mixed. The Federal Judicial Center found that patent cases moved faster in front of the judges who had this enhanced patent experience than in front of generalist judges. So that was beneficial. This study found that the decisions of the pilot judges were not appealed as often as the decisions of the non-pilot judges, suggesting that there was more dissatisfaction with the more generalist judges, although that wasn't a huge difference. Interestingly, though, in the cases that went from the pilot judges to the federal circuit and the generalist judges to the federal circuit, there was no difference in reversal rate. The reversal rate was the same. So I think the result of all of this is it hasn't resulted in a strong move to create more specialized judges, although time will tell. Maybe some will have that feeling. In terms of the advantages, you all understand the advantages of specialist judges. I do think there is some benefit that comes from non-specialized judges in that they can bring original thinking and principles from other areas of the law that often bear on cases that are involving IP.
네, 감사합니다. 다음으로 영국의 리차드 헤이콘 판사님 부탁드립니다.
Thank you. So far as the selection criteria are concerned for specialist IP judges, As I mentioned earlier, they're all drawn from practitioners, barristers and solicitors who have practiced in IP law previously. So they arrive at the bench with a very good knowledge of IP law. Most IP litigation is still in London, although there's an increasing tendency to try and move it outside London. But one of the difficulties is all the specializations tend to be in London, so there's resistance to doing that. What about the advantages and disadvantages of having specialized IP judges? Well, the advantages we've found, I think, reflect what David has just been saying about the pilot. The advantages are that the procedure leading up to the trial and the trial itself tend to be conducted more quickly and more efficiently if the trial judge is an expert, for two reasons. One, because he or she is familiar with the law, and two, because they tend to have a technical background. All the full-time specialist IP judges sitting at the moment have a science background. The judges who hear more general IP, trademarks, copyright, and so on, the majority have no science background at all. But I think it matters less than when you're hearing, for example, a patents case. But there's another reason, there's another advantage in having specialized judges which applies in the court of which I'm presiding judge. I sit in the patents court quite a lot, but I'm presiding judge of IPEC, which is designed to give less costly and more rapid access to justice for small and medium-sized enterprises. And that's only possible if the judge, in controlling the case, can make rulings about limiting the amount of evidence that can be used, the amount of documents that are going to be disclosed, and I even have the unusual power of being able to disallow certain arguments that a party wants to run, so that the case is focused down to the essentials of the case, and then it can be conducted more quickly, more efficiently, and at less expense. Now, that is only possible if the judge making those rulings knows quite a lot about IP law, because if you don't, then you're faced with arguments from advocates that this or that argument is absolutely essential to their case. And unless you know quite a lot about IP law, it's difficult to give a reliable ruling disallowing them to run that case or limiting the amount of evidence. So that's one of the advantages of having specialist IP judges. Disadvantages? Well, I think when I used to practice as a barrister before I became a judge, I used to appear before judges who were not specialists in IP law. And occasionally I found it quite refreshing that they brought a new insight or a new approach to an aspect of IP law which had just become, everybody assumed that this was the correct approach, and sometimes it's a good idea to have a fresh perspective. And that can be useful. Finally, are there any education training programs? Yes, we have training programs, but they are not specifically designed for IP for the most part. They are more general judges training programs. Thank you.
네, 감사합니다. 다음으로 히로아키 이마이 판사님 부탁드립니다.
The question of the specialized IP judges, my answer is no. In Japan, the judges are legal experts appointed from among those who have passed a bar exam and completed the required legal apprenticeship in principle, but not specialized for the IP-related cases. So, our judicial research officials and technical advisors who have specialized knowledge on technical fields assist judges I will explain later. Concerning about the advantage and disadvantages, normally said the advantages of the specialized IP judges are the expertise and the specialty, and there's no doubt about it. On the other hand, IP-related laws are part of the civil law system. General laws, including the Civil Code and the Civil Code of Civil Procedure and the Civil Execution Act, are also relevant to IPR enforcement in areas in which IPR has no special rule. For example, conflict from the trade secret acquired through collaborative research will be treated primarily as a breach of contract or tort. So, in my personal opinion, there will be disadvantages of specialized IP judge if he or she does not have some knowledge, if as a judge who have not enough experience in the civil law areas. And the educational programs for IP judges are now concerning about it. Judges who are appointed to the IP divisions are frequently transferred back to one of the IP special divisions and the IP court to further develop their IP-related law and technology experience. For my personal experience, I am here, I'm as a judge of the IP High Court this April, but this is my second time as an IP High Court judge. I always have 2 times experience as the IP District Court judge at Tokyo District Court. Our Supreme Court, every year, a Supreme Court dispatches judges to the foreign institute and universities to learn IP laws and the foreign practices. This is our program. Thank you.
네, 감사합니다. 다음으로 한국특허법원의 이지영 판사님께 프레젠테이션 부탁드립니다.
예, 특허법원은 지식재산 전문 법원이긴 하지만 한국에서는 지식재산 전문 법관이라는 명칭을 사용하는 제도는 없습니다. 따라서 선발 기준이나 자격 조건도 명시적인 것은 없다고 볼 수 있습니다. 현재 특허법원을 구성하는 법관들은 법원장님을 제외하고는 다음과 같이 구성되어 있습니다. 보시다시피 먼저 이제 판사는 법관 경력 15년 차 미만의 법관들로 지방법원에서 근무를 하다 순환 인사의 일환으로 특허법원에 3년 동안 근무를 하시고 다시 지방법원 판사로 돌아가시거나 대법원 재판연구관 등으로 또 보직이 변경됩니다. 그리고 특허법원에 근무하는 고등법원 판사의 경우에는 모두 법관 경력 15년 이상인데 그중 일부는 서울 고등법원에서 고등법원 판사로 선발된 이후 10년 이상 근무한 다음에 순환근무의 일환으로 특허법원으로 다시 오십니다. 오셔서 3년 정도 근무하신 이후에 다시 또 서울 고등법원 등으로 복귀를 하십니다. 그리고 마지막 한 그룹으로는 저를 포함한 일부 고등법원 판사들이 있는데요. 지방법원 부장판사 혹은 부장판사가 될 시기에 특허법원에서 장기 근무를 하는 기회를 얻게 되는 경우입니다. 한국에서 특허법원, 지식재산 소송 법관의 전문성이라는 것은 대체로 전담재판부나 특허법원에서의 이전 근무 경력이라든지 혹은 법관이 되기 전에 IP 전문 변호사 또는 변리사로서의 어떤 경력 그리고 개인적으로 가지고 있는 어떤 이공학 전공 여부 또는 지식재산권법 전공 여부 등을 통해서 확보를 할 수 있는 것으로 보이는데요. 지금 특허법원 판사님들 중에서도 일단은 모두 다 법률 전문가 전문가들이시고 그 중에서 일부는 대학원 등에서 지식재산권을 전공하신 분도 계시고 또 일부는 약 한 40% 이상인 것으로 확인이 됐습니다만 뭐 대학이나 대학원에서 이공학을 전공하신 분들도 있습니다. 그래서 뭐 기계나 전기전자, 뭐 수학, 뭐 약학, 컴퓨터 사이언스, 수의학까지 다양한 분야를 전공하신 판사님들이 근무를 하고 계십니다. 전문법관 제도 자체는 전문성을 기반으로 한다면 신속한 결론 도출은 가장 큰 장점이 될 수는 있을 것 같습니다. 좀 전에 캠벨 판사님께서 말씀하셨던 그 PPP 프로젝트의 결과와도 비슷한 것 같습니다. 다만 이게 너무 전문성에 치중을 하다 보면 다른 법률과의 조화로운 해석을 놓치지 않도록 늘 조심을 해야 된다라는 점을 좀 생각하고 있다고 말씀드릴 수 있습니다. 그리고 법관 교육 프로그램에 대해서 말씀을 드리자면 일단 대법원 산하 지식재산권법을 연구하는 법관들의 연구 모임이 있습니다. 이것은 꼭 뭐 특허법원 소속이 아니더라도 희망하시는 모든 법관께서 참여를 해서 IP에 대해서 연구를 하실 수가 있습니다. 특허법원에서 운영하고 있는 교육 프로그램이라면 뭐 판사를 교육시킨다는 그런 의미는 아닙니다. 법관과 기술조사관, 로클럽 전부를 대상으로 해서 2020년부터 매년 약 16주에서 20주에 걸쳐서 일주일에 1회 정도 대학의 교수님들께서 직접 오셔서 다양한 그 첨단 기술 과목을 강의를 하고 계십니다. 지금까지 실시했던 그 과목으로는 뭐 약제학, 그리고 반도체, 유기화학, 인공지능, 뭐 에너지 분야 등을 들 수 있겠습니다. 이상입니다.
네, 감사합니다. 다음 소주제 토픽 4로 지식재산 소송 전문화를 위한 또 다른 방안에 대하여 알아보겠습니다. 지식재산 전문법관 제도를 두지 않는 국가이건 또 전문법관 제도를 채택한 국가이더라도 법관이 기술적인 배경이 없는 경우도 있고 설령 있더라도 모든 분야의 기술을 파악할 수는 없습니다. 따라서 법관의 기술적 이해를 돕기 위한 제도를 둘 필요가 있는데요. 기하의 국가에서 기술조사관 제도, IP 소송 전문성을 가진 로클럭 선발, 그 밖에 법관의 기술적 이해를 돕기 위한 제도를 두고 있다면 각 3분 내에서 상세히 소개하여 주시기 바랍니다. 다만 전문심리위원 전문가 정인 제3자 의견 진술 제도는 다음 질문에서 다룰 예정이오니 이 부분은 제외하시기 바랍니다. 먼저 데이비드 캠벨 판사님 부탁드립니다.
In the United States, in federal court, we do not have technical examiners who assist judges. We do use expert witnesses, but that will be addressed in just a moment. Federal judges do have law clerks. These law clerks are hired by the judges themselves. They work for the judges, often for 1 year, although in some instances for longer periods of time. These law clerks are law school graduates, usually with excellent credentials. They've done well in law school or they have additional work experience after law school. But they do not have, typically they do not have technical expertise because they assist the general jurisdiction judge in the full general jurisdiction calendar and have to be able to provide research and writing assistance in all of those areas. Within the federal circuit that I mentioned a minute ago, those judges, each of those judges on the federal circuit has 4 law clerks that work for them, and they often do look to hire law clerks who have some technical background or experience, although it's not a requirement. The judges make their own hiring decisions. The Patent Trial and Appeals Board judges within the Patent and Trademark Office also have a law clerk experience, or pardon me, a law clerk program where law clerks are hired after law school to come and work for them and specifically to gain patent experience. That's really the only direct assistance that judges receive.
감사합니다. 다음으로 리차드 헤이콘 판사님 부탁드립니다.
The procedure. Thank you. I'll try from a little further away. The procedure in England allows judges to have technical assistants, that's to say a technical expert, sitting with them on the bench. The judge can ask for it, or the parties can suggest it. The judge has to approve. But it's almost never happens. It's really quite rare. We tend to rely on the experts who are appearing with the parties. Each party on each side has a technical expert, where it's a technical case, obviously. And the judge relies on their evidence, weighing up their evidence, to be informed about the technology and to reach a conclusion. What's more common than a technical assistant sitting with a judge is to ask the parties to agree what we call a technical primer. That's to say, an agreed written explanation of the technology in question, which is provided to the judge in advance of the trial. For example, early next year, this is a case in the Patents Court. It's a semiconductor case. It's not possible to assess infringement by direct measurement of anything or looking at anything. It'll be done by reference to mathematical models. So I've asked for a technical explanation of how the mathematical models are constructed in advance, so that I will have some chance of understanding the cross-examination of the experts when it happens. If a technical assistant does sit with the judge, they are strictly not allowed to say anything about the rights and wrongs of the case or the result. They are just there to give technical assistance. We don't have law clerks at first instance, or in the Court of Appeal, actually, unfortunately. First instance judges are expected just to do everything by themselves and write the judgments by themselves, with this slight exception. There are junior lawyers who are in the court building who are not attached to any particular judge, but can be requested to do particular tasks for first instance judges. But otherwise, we're left to get on with it ourselves.
네, 감사합니다. 다음으로 히로아키 이마이 판사님 부탁드립니다.
Okay. We adopt a system of judicial research officials. Full-time judicial research officials are court staff members assigned to the IP High Court and also the intellectual property divisions of the Tokyo and Osaka District Court, consisting of former Japan Patent Office trial examiners and patent attorneys who have specialized knowledge in technical fields. IP High Court has 11 judicial research officials. Yesterday, at the welcome dinner table, I explained 17 judicial research officials. I have the anxiety, and I came back to the hotel room and I counted from this level, and counted from this photo. That was 11. I'm very sorry about the member of the table. So, judicial research officials assigned to the court conduct researches by order of judges on technical matters as required to conduct proceedings and render judgment in case relating to patents, utility models, and other intellectual property. From April 2005, they may, with permission of the presiding judge, ask questions to the parties during oral arguments or other occasions in order to clarify the facts of the case. So we don't have law clerk for IP litigation, but I have heard the explanation. I personally want to be helped by law clerk. Thank you.
네, 감사합니다. 다음으로 이지영 판사님 부탁드리겠습니다.
예, 특허 사건은 관련 기술에 대한 이해가 전제되어야 합니다. 그래서 한국에서는 판사님들의 기술적 이해를 돕기 위해서 기술 심리관과 조사관 제도를 도입을 했습니다. 그래서 이분들은 전문 과학 분야를 가진 법원의 구성원들입니다. 기술 심리관 분들은 주로 특허 심판원, 심판관 등의 경력이 있는 분들입니다. 심판원에서 일시 사직하신 후 2 내지 3년간 특허법원에서 서기관으로 근무를 하고 계십니다. 그리고 일부 기술 심리관 및 조사관 분들은 법원에서 직접 채용하기도 합니다. 이분들 역시 박사급 이상의 전문 기술 지식 분야를 가진 분들입니다. 특허 소송이 제기가 되면 여기 PPT 표에 나와 있는 것처럼 기술 심리관 분들에게 가장 적합한 그 기술 지식을 가진 분들에게 사건이 배당이 됩니다. 그럼 이분들은 기술 내용과 쟁점을 정리한 기술 검토서를 법관에게 제출을 하고 재판부에게 직접 설명을 하십니다. 그리고 법정에 출석하셔서 재판장의 허락을 받아서 직접 질문을 하는 경우도 있습니다. 기술 심리관 분들이 그런 역할을 하고 계시고요. 또 오른쪽 그래프에서 보시는 바와 같이 기술 심리관 조사관 분들은 이렇게 다양한 전공 분야를 가지고 계십니다. 그래서 이분들을 통해서 법관의 어떤 기술적 이해에 많은 도움을 얻고 있다라고 말씀드릴 수 있습니다. 다음으로 로클럭 제도에 대해서 말씀을 드리자면 특허법원에는 현재 4분의 로클럭 분들이 근무를 하고 계십니다. 다만 미국과는 달리 로클럭은 법관 개개인이 선발을 하지 않고 사법부에서 고등법원 단위로 선발을 하고 있습니다. 따라서 특허법원 로클럭만의 특별한 선발 요건이나 자격은 현재로서는 없는 것으로 알고 있습니다. 다만 로클럭 지원하시는 분들은 희망 근무 법원을 밝힐 수 있고요. 그리고 로클럭을 배치할 때에는 이분들의 희망뿐만 아니라 전공 여부까지도 모두 감안하는 것으로 알고 있습니다. 그래서 현재 근무하시는 분들 중에서 2분의 로클럭 분들은 화학공학과 컴퓨터 사이언스를 전공하신 또 이공계 경력이 있는 분들입니다. 다만 로클럭 분들은 보통 상표나 디자인 사건 혹은 민사 침해 소송의 검토를 담당을 하시는데 재판부가 희망하는 경우에는 특허 사건에 대해서도 조사를 해 오시기도 합니다. 이런 경우에는 이공계 경력 부분도 상당히 도움이 되지 않나라고 생각하고 있습니다. 이상입니다.
네, 감사합니다. 마지막 토픽 5로 앞서 논의한 내용들 이외에도 지식재산 소송의 전문화를 위해 귀국에서 채택하고 있는 제도가 있다면 소개를 바랍니다. 예를 들면 전문심리위원, 전문가 증인, 제3자 의견 제출 제도, 지식재산 소송을 위한 법정의 시설 등을 중심으로 말씀해 주시면 감사하겠습니다. 배심제를 운영하는 국가의 경우 IP 소송 전문성을 확보하기 위한 별도의 방안이나 배심원을 기술적으로 보조하는 제도 등이 있으면 소개해 주시면 좋겠습니다. 3분 정도 범위 내에서 발표를 부탁드리겠습니다. 먼저 데이비드 캠벨 판사님 부탁드립니다.
Thank you. When a party applies for a patent at the Patent and Trademark Office in the United States, they make that application before a specialized patent examiner. These examiners are skilled engineers and scientists who work with the applicant over a period of time to determine and sometimes refine the patent and ultimately decide whether a patent can be issued. When a patent case comes to our general jurisdiction federal courts, as Richard mentioned, in England, judges do have the ability under our civil procedure rules to appoint an expert for the court to advise on technical matters, although that is almost never done. More commonly, as was also mentioned, we rely upon experts that the parties provide, and it's common for each party in a case to come forward with an expert. It's a good technique, in my view, case management technique, to do what Richard describes, and that is bring both experts in at the same time and talk about the science and educate the judge on the science, but that's discretionary to a judge. As to whether third parties can provide input to courts, they can. We have an amicus brief or friend of court brief practice in the United States. It doesn't happen often in the trial courts, although sometimes it does. On appeal, parties will file amicus briefs, often academics or businesses or government entities or nonprofit organizations with an interest in the outcome of the case will file a friend of court brief, and the judge can read it for what benefit it provides. With respect to juries who decide cases, there are no specialized criteria for selecting technically trained jurors. Jurors in the United States typically are drawn from the voter rolls and the driver's license rolls, and they're regular citizens who are called in at random to appear for jury trial. There are no specialized procedures for training them. In patent matters, there are no specialized programs for training them. Instead, it's the responsibility of the judge to give them the legal instructions on the law that applies, including the claim construction in a patent case. And the jurors will hear from expert witnesses that the parties provide to help educate them, but there is no other special qualification or training for jurors.
네, 감사합니다. 리차드 헤이콘 판사님 부탁드립니다.
So far as expert examiners are concerned, we have no expert examiner of witnesses in the court. As in the US, and I think in most jurisdictions, when a party applies for the patent, it goes to an expert examiner in the intellectual property office. But in the court, there's no such thing. As I mentioned a moment ago, the judge is almost always instructed in the technology by evidence given from the expert witness, or sometimes more than one expert on each side. If it's a technically complex case, there may be different aspects to the technology, so you may get 2 and occasionally even 3 expert witnesses on each side, and those are cross-examined by the advocate on the opposing side, which just means sometimes there's a misunderstanding of cross-examination. It just means questions asked by the advocate on the opposing side. And in IP courts, that's usually a reasonably polite exercise. It's not an aggressive approach. One of the advantages of the cross-examination system, though, is that the expert who's giving evidence knows it's going to be tested, which means they don't give lightly evidence that they can't back up, can't justify in court. So even before you get to court, it provides a corrective to the experts to make sure that what they say is accurate, because it's going to be tested. Third-party amicus briefs, it's possible under the system. It's very unusual in IP cases. A third party must have a very good reason to intervene, but if there's a good reason, it's allowed, and it does happen. Court facilities for IP litigation. All the courts have large screens so that witnesses can appear by video link. This happens more frequently than it used to, especially since COVID. It's become quite common. Instead of having the expert flown in from Seoul or Tokyo or wherever the expert professor lives, they instead appear by video link in the court, and the evidence is taken that way. It saves time and trouble. So all the courts are equipped to do that. And short hearings, if it's a very short, just a short hearing, it's common to have the entire thing conducted by video link so that nobody has to travel to the court. If the case is, say, a half a day or less, it's common just to have the entire thing done by video link. Thank you.
네, 감사합니다. 다음으로 히로아키 이마이 판사님 부탁드립니다.
So I would like to explain the technical advisor system I have already mentioned. The technical advisor system aims at achieving higher quality of court proceedings and judgment in specialized fields of lawsuit, such as intellectual property cases, in which scientific and technological matters are often disputed. And at this time, this system, experts who have a wealth of knowledge in relevant scientific fields are asked to participate in court proceedings as technical advisors. They provide judges and parties from the viewpoint of a fair and neutral advisor with explanations on the technical matters involved in the lawsuit. These explanations are helpful for judges to have a better understanding on the technical aspects and to narrow down legal and factual issues of the case. About 200 technical advisors appointed nationwide. About expert witness. Expert witness about infringement may be designed by the courts to provide their opinion on matters requested by the courts. However, these expert witnesses are rarely used in actual cases in practice. Rather, parties submit a document private expert opinion, which is an opinion letter of an expert requested by the parties. But the petition of the expert opinion for calculation of damages shall be accepted if in need. Patent Act Article 105/2 prescribes that litigation involving the infringement of a patent right or violation or exclusive license, if the court, at the motion of a party, orders an expert opinion in order to calculate the damages from the act of infringement, the party must explain to the expert witness the details that need to be explained in order for the expert witness to give an expert opinion. This provision applies mutatis by Trademark Act Article 39 and Design Act Article also. A third party opinion, amicus brief. Amicus brief proceeding is one of the procedures for the collection of evidence that was newly introduced by the amendment to the Patent Act in 2021, but it is very rare. And we have documentary evidence. We have another court facility for IP litigation system called MINT, but it is on the booklet, so I didn't explain. I don't explain. Concerning the jury system of IP trials, we don't have jury system. Thank you.
네, 감사합니다. 한국의 이지영 판사님께 부탁드리겠습니다.
네. 먼저 전문 심리위원 제도를 말씀드리겠습니다. 민사소송법에 기해서 법원은 특허소송에서도 전문 심리위원을 활용할 수 있습니다. 오른쪽 그래프에서 보시는 바와 같이 기술과 관련된 여러 전문 심리위원 후보님들이 확보가 되어 있습니다. 전공 분야도 다양하시고 대학 교수나 박사 이상의 기술 전문가들이라고 할 수가 있습니다. 재판부는 해당 사건에 가장 적합한 전문 심리위원 후보들을 선정을 해서 전문 심리위원으로 활동하시게 합니다. 이분들은 주로 해당 사건을 검토한 후 기술 관련 설명과 의견을 제시한 서면을 제출할 수도 있고요. 또 기일에 출석해서 또 직접 설명이나 의견을 하시기도 합니다. 또 재판장의 허가를 받아서 소송 관계인에게 또 여러 가지 질문도 하실 수 있습니다. 다음으로 전문가 증인에 대해서 말씀을 드리자면 역시 민사소송법에 근거해서 특허소송에서도 전문가 증인을 선정할 수 있습니다. 주로 통상의 기술자의 기술 수준이나 실시료, 그다음에 선행 발명의 내용이라든지 기술 대비 등을 위해서 선정을 하고 있습니다. 법원이 직권으로 선정하는 경우보다는 당사자들이 신청에 이어서 이루어지는 경우들이 더 많다고 말씀드리겠습니다. 다음으로는 그 전에 이제 제3자 의견 제출 제도에 대해서 말씀을 드리자면 한국은 미국과 같은 제3자 의견 제출 제도는 없습니다. 다만 원고와 피고가 본인의 주장에 부합하는 전문가들의 의견을 준비 서면에 담아서 주장을 하거나 그런 의견들을 증거로 제출할 수는 있습니다. 그러면 법원에서는 여타 다른 증거와 마찬가지로 자유롭게 선정해서 결론을 내릴 수 있다라고 말씀을 드리겠습니다. 마지막으로 지식재산 소송을 위한 법정 시설을 말씀드리자면 2021년부터 한국은 전자소송을 시행해 왔고요. 지금 현재 특허법원의 소송은 전부 전자로 진행하고 있습니다. 그래서 기본적으로 화상 실물화 장치라든지 컴퓨터 등은 당연히 설치가 되어 있습니다. 특히 특허 소송의 변론기일에서는 원 피고가 직접 기술 설명을 합니다. 오늘 참가하신 많은 변호사님들께서 이런 역할을 담당해 주시는데요. 변론기일에 직접 파워포인트 등을 이용해서 기술 관련 쟁점, 법률적인 쟁점을 모두 설명을 하고 계십니다. 가끔은 직접 물건을 가지고 나와서 보여주시기도 하고 관련 동영상도 보여주시고요. 사진, 도면을 직접 제시하기도 합니다. 이런 과정을 통해서 법관은 좀 더 기술을 쉽게 파악할 수 있다라고 말씀드리겠습니다. 이상입니다.
네, 감사합니다. 벌써 예정된 시간이 거의 다 됐는데요. 자료집을 보시면 아시겠지만은 패널 분들께서는 각국의 IP 소송 전문화 방안에 대하여 서면으로 아주 자세한 설명을 해주셨습니다. 아마 소중한 자료가 될 것 같습니다. 그렇게 자세한 설명을 해주셨는데 불구하고 한정된 시간으로 인하여 준비하신 답변에 비하여 너무 짧은 발표 시간밖에 못 드려 죄송하게 생각을 합니다. 패널 분들로부터 마무리 말씀을 청해 듣는 것으로 1세션은 마치도록 하겠습니다. 마무리 말씀은 좌석에 착석한 순서대로 듣도록 하겠습니다. 먼저 이지영 판사님 부탁드립니다.
예, 1세션이 끝났습니다. 먼저 참석하신 판사님들이 너무나 유명하신 분들이라 마이크가 놀라지 않았나 싶습니다. 초반에 원치 않은 하울링 때문에 많이 고생하셨을 것 같은데 패널 분들 그리고 청중 여러분께 주최 측을 대표해서 양해의 말씀 구하겠습니다. 1세션 잘했지만 무엇보다 가장 잘한 것은 여러분들의 소중한 점심시간을 지켜드린 게 아닌가 생각합니다. 예, 들어주시느라 너무 고생 많으셨습니다. 감사합니다.
네. 데이비드 캠벨 판사님 부탁드리겠습니다.
Well, I guess I'm done. I've appreciated the chance to be a part of this panel and to hear the similarities and the differences among our various countries. I look forward to discussions the rest of today and tomorrow to learn more so that we can take valuable ideas back to our courts and our country.
네, 감사합니다. 리처드 헤이콘 판사님 부탁드립니다.
Is it on? Ah, it's on. Well, no, it's yeah. I think this morning's conference has proved what I've often found when speakers from different jurisdictions discuss their procedures and approaches to matters of IP law. It's always very valuable to learn from other jurisdictions. I think all of us, especially lawyers perhaps, have a tendency to think that a particular approach must be the right approach because that's how we've always done it and we've never really thought about anything else. Well, I always find it very useful to hear from other judges that there is a different approach And I think that is a healthy way of encouraging us all to think about our own systems and whether they can improve. And there is always room for improvement. I would lastly say that this is being conducted, I think, almost exactly on time, so I congratulate the moderator in particular.
네, 감사합니다. 히로아키 이마이 판사님 부탁드립니다.
Yeah, thank you very much. And I have learned a lot of things from them, and we have to continue the continuous effort to make the litigation system more efficient. So thank you very much.
네, 감사합니다. 한지윤 판사님 부탁드리겠습니다.
예, 그 각국의 지식재산 전문법원의 운영 현황과 그 관할을 비교해 볼 수 있는 상당히 뜻깊은 시간이었습니다. 특히 저는 많이 배울 수 있어서 감사드리고요. 그 경청해 주신 청중분들과 또 많은 시간을 할애하셔서 준비해 주신 우리 패널 분들께 특별히 감사드립니다. 감사합니다.
네, 1세션은 이것으로 마무리하도록 하겠습니다. 온라인으로 모두 참석해 주시는 여러분 모두에게도 감사드립니다. 네.